but I was asking if he had shown any signs to her.
Again, not necessarily directly part of your investigation, but what someone else might perceive of Mr. Singleton, correct?
Yes. Which is something I do pretty much at every time someone goes to the hospital to see what they observed in my absence.
Trooper Whirling, are you familiar with how that relates to HIPAA or any other consents that may be affected with you asking that question?
I do not, but she didn't answer. They gave me.
And so when you entered the room, Mr. Singleton was laying in the hospital bed, correct? And Mr. Singleton provided you with what his account of the crash involved, correct? And do you recall Mr. Singleton also saying that there were deer in the roadway?
Yes, I do recall that. I just can't prove that because I don't have any evidence.
But you also can't disprove that, can you? And Mr. Singleton immediately starts talking to you, correct?
Yes. Yes.
Trooper Whirling, excuse me for interrupting. You married? You have children? The children ever misbehave? So do you speak to your children when they're misbehaving in as quiet a voice as you're saying today? It'll work. See that guy standing in the back of the courtroom? I want you to talk loudly enough that you can think he can hear every word, because your voice is so black, so soft, that it's difficult for everyone to be able to hear it. Now, none of these jurors are as old as I am, but I am just telling you that it's difficult for us to hear and understand, and it's important for everybody to understand everything you're saying. So to speak as though you were a little bit angry at somebody, apparently you never get angry at your children, and that may be nominating you for sainthood. I don't know. So, just try to speak as loudly as you can to project.
Trooper Whirling, it was apparent to you that Mr. Singleton did sustain injuries, correct?
Yes, that is correct.
And again, refresh my memory, what time of day is it that you're at the hospital?
So I arrived at the crash at 1:47. I arrived at the crash at 2:49. And then I got to the hospital around 4:03. I know that I did the consent form, filling out form. I started at 4:19. And then I know the signature for the blood draw was at 4:33. So the exact time I arrived at the hospital.
Now, as Mr. Singleton is laying there, it was your testimony that he had watery eyes, correct?
Yes.
You just testified that this is at 4 o'clock in the morning, correct?
That's true.
You also just testified that you were aware that he had injuries, correct?
Yes.
Wouldn't it be reasonable that he could possibly have watery eyes at 4 a.m. in the morning, and due to the fact that he was possibly in pain?
That's true. It is also an indicator for my investigation for that.
But it is reasonable for one to think that that could be related to the time frame and the injuries. Now, you testified that Mr. Singleton was cooperative, correct?
He was. He didn't refuse to answer any of my questions.
And I believe it was your testimony, and correct me if I'm wrong, but you testified that one of the things you gauged your investigation on was speech, correct?
Yes, that is true.
But Mr. Singleton did not have slurred speech, correct?
Not that it was slurred. He That's how it's a southern accent maybe.
Okay, but just for purposes of your testimony, I don't want any confusion. His speech was not slurred, correct?
No,
And Mr. Singleton didn't have any problems understanding your questions, correct?
I don't believe he misunderstood my questions. I was just concerned about the way he did answer. Typically, I ask the question, the patient or the therapist, they answer that question and pretty much the end of it. So it's the fact that we can continue on, had a little story to go with, some of it did match what I was talking about and some of it didn't.
So in your opinion, he was overly talkative?
Yes.
Now, you're familiar with the NHTSA standards as far as indicators for DUI, correct?
Mhm.
Then you would agree with me that talkative is not one of those indicators, correct?
It is an indicator in our, like, if you have the report in front of you, the levels of talkativeness is on there.
My question was, is that a known indicator of NHTSA? What governs field
The field
sobriety?
sobriety is not part of the field sobriety, but it's still part of the DUI investigation.
Let me ask you this, Trooper. So, in any of your encounters through your career, if someone is talkative, they're immediately impaired and unable to operate a motor vehicle?
No, the talkative portion, or if it's somebody who doesn't speak up there, without being hostile, but they don't feel like they're not able to continue speaking, those are just extra indicators that go along with your field sobriety test.
And Mr. Singleton was not hostile, correct?
No, he was.
And so how long would you estimate that you were in the hospital room with Mr. Singleton? I'm just asking. I didn't
I'm assuming.
clock on it, but okay.
Possibly.
And so within that 30 to 40 minutes that you were in the room with him, you never detected an odor of alcohol, correct?
No, I did not smell.
And I believe it was your testimony that due to the fact that Mr. Singleton was in a hospital bed, you didn't conduct any standardized field sobriety tests.
I didn't conduct any field sobriety tests that required him to do physically stand up or to have to walk.
And you would agree that those are commonly used to determine whether a driver is impaired, correct?
Yes, those are part of the field sobriety test.
You yourself had no observations of him walking prior to or during that encounter with him, correct?
No, he was in the encounter.
And based on your body cam footage, there were no coordination tasks asked or required of Mr. Singleton, correct?
Yes, correct.
Are you familiar with some of those coordination tests that I'm speaking of?
Yeah.
But you didn't ask him to do any of those, correct?
No, you can't have those if you don't have the three first tests. You can't have the alternate.
So based on that response, then you would agree that your only indicators up to that point were watery eyes and Mr. Singleton was overly talkative, correct?
I had other indicators. I personally had other indicators, but I don't believe I can speak on those.
Ladies and gentlemen, step across the mic, please. Mr. Atchison, it seems to this court that you have cracked the door, if not kind of kicked it open partially, regarding the stigma gaze test by continuing to ask the officer about the fact, emphasizing that she had made no observations about him that would have led her to charge him. We all know that she performed the stigma gaze test, which she, by law, is not entitled to testify as to the results. But it seems to me that in answer to your question, and I appreciate you all, Trooper Whirling, for hesitating before you began to answer the question, because I tried to keep that from the jury that they would hear about an inadmissible test. So we're faced with then allowing her to answer the question that yes, she had made other observations physically about him, but not go into the nature of those observations, which of course was raised to the jury's mind. But I think the continued emphasis that you have placed on your cross-examination about she made no observations of no field sobriety test, no observation, when there was in fact a test, but it's just that you're objecting to the introduction of that test. So I'm going to allow the state to address that issue.
Your Honor, are you asking me what I want to do?
I'm just asking you, do you believe that it's, if there's anything, we'll bring the jury back in and just allow her to continue to not answer any questions or to state that there were no physical observations. But I'm just saying that you're perilously close to allowing her the opportunity to testify by questioning and emphasizing the fact that there were no tests whatsoever, no observations. She didn't see anything, when in fact she did. She performed a test that they're trained to test that shows that there was an indication at a 45-degree angle of the eye jumping that would allow them to indicate that there was a presence of alcohol, which would then allow her to go forward with other testing. She couldn't because he was in a hospital bed. So my concern is that, and the reason I sent the jury out is I just want to caution you about this line of questioning that's been over and over about the no physical testing or anything such as that. And if it continues down that way, then it seems to me that the state would be, entitled to particularly some form of questioning about her having another test that because I think she's already said that once in her direct examination that there was a test that she performed, but she didn't go into it. So.
Yeah, Judge, I guess the state's concern is that jury may feel like evidence is being withheld from them, and I don't know, I kind of feel like the door has been opened a little bit here, and I would like the opportunity to ask her about that test due to him opening the door and hammering on it over and over. But
Judge Miles,
I'm just concerned about that now that
I don't think that I'm basing those questions off of her direct testimony and the fact that what she's testified to is the only direction that I've went with that line of questioning.
well, that's not exactly what you said. There's a fair to just say so the only things you observed were you didn't say the only thing you testified to.
You asked her the only things you observed and the only basis you made a decision on were this, and you're omitting what she actually did base her decision.
But Judge, you've already ruled on that.
Pardon?
But you've already ruled on that separate motion hearing.
And I've already ruled on the stigma gaze test.
Correct.
Yeah, I mean, and it is inadmissible unless she's been properly trained. There's a difference between admitting it as substantive proof in the state's case in chief and the door being open to allow them to testify, allow this witness to testify. Yes, there was another test within the court instructing the jury. There was another test that she relied upon. However, it would require for it to be introduced as substantive evidence, training that this witness does not have, and therefore I excluded that evidence. But there was another test that she relied upon. The implication that you keep asking her is that she didn't have anything that she was basing this decision on. And I'm just saying, from the state's perspective, and I don't care one way or the other, but it seems to me that in fairness, that because you have reemphasized the fact that these were the only things that she considered in making her decision, that the state may have an argument that allows them to try to raise that issue. So,
Judge, I would like to be able to raise it, redirect, I guess is what it would be. But she did, I wouldn't have to go into it painstakingly, I wouldn't have to show the video, but I could ask her, you did do an additional test, and ask her what the test is, if Your Honor would allow me to do that. And Your Honor could make that clarifying instruction with the jury without it not being substantiated proof. But I just feel like she's kind of being made to look like she just barely did anything. And
the reason this issue has arisen is, and I'm not fussing at you, but I'm just saying the only reason that this issue has arisen is your repeated questioning of the witness, in which you emphasize that these were the only things that she has based her decision on charging them with. And clearly, I think to allow the state to then rebut that by saying there was another test, that but that test would require medical training to be able to introduce the results of what they meant.
still go into it a whole lot, but clarify that she did do something else.
I think it's fair at this point to simply say, I'm not going to allow the test itself,
Yes.
but I am going to allow the question to be asked as to whether or not there was on redirect. State can ask the question, so don't answer. You can answer in answer to his question that there was other evidence. And then if he chooses to ask you the question, what was that other evidence, then you can testify about what it was. But I don't think Mr. Atchison is going to ask that question.
No, that wasn't the direction that was going anyway.
So when the jury comes back, we'll allow you to continue your cross-examination. I'm going to tell them that I have taken up a matter outside of their presence, that I have made certain rulings and opinions about certain evidence, and that will be dealt with later in the case. So,
Thank you.
all right, then we direct that.
Yes, sir.
All right. Mr. Atchison.
Trooper, I believe it was your testimony that you read Mr. Singleton the implied consent form, correct?
Yes, ma'am.
Do you recall making the statement just to make sure you didn't have too much alcohol in your system?
Yes, so that when you get the blood images, you can see how much alcohol is in the system, and it can show whether the person was overly living or underly living.
And so based on that testimony, your request at that point in time was precautionary, correct?
I don't think precautionary. It was just as a way to explaining to the driver, like the justice system.
But you also testified that the toxicology report indicated a BAC of 0.11, correct?
Yes, that is true.
But you can't sit here and testify today as to what Mr. Singleton's BAC was when he was operating his motor vehicle, correct?
I cannot testify to it, but the blood test itself can show what his blood alcohol level was at the time of crash. So,
Just to clarify, the blood result is going to show what Mr. Singleton's BAC was when it was drawn, correct?
Yes, the test results show what his blood level, what alcohol level was at the time it was drawn.
Correct.
The test has I don't know the formula for it, but there's a mathematical formula that shows how much blood was in that first resistance previously.
But you can't testify as to what his BAC was when he was operating his motor vehicle, correct?
No,
Trooper Worling, do you read implied consent on every crash you investigate?
on every crash, no, only ones where I think the parent is involved.
As it relates to the blood draw, and based on your body cam, was the seal of that blood sample, was that initial by any medical staff?
It's not the seal of the blood vial that's initiated, it's a label that goes on and you put your initials and everything on the label.
So there's a label that goes around the tube?
Yes, so it identifies who the blood came from, like when it was taken, and the paperwork that goes with it shows who the person is who gets drawn.
And so that label was on this particular sample?
Yes,
Did you observe the label being put on the sample?
I observed her writing all the information on it. They didn't have it. Some hospitals have it printed out, where you can just print off the label and put it on there, but they did not have it. She had to do some writing.
And just for clarification purposes, it's your testimony that you did not determine a specific cause for this crash, correct?
That is correct. I did not say that he crashed because of specific.
And you agree with me that the blood test result only shows concentration of alcohol at the time of the draw and not at the time that he was operating his motor vehicle, correct?
The blood test results shows what it was at the time of the draw.
Correct. No further questions.
You're right.
Yes, Judge, brief. Trooper, Mr. Atchison, he asked you about different things that can cause someone to crash on the roadway, correct?
Yes,
Would it be true or accurate to say that driving while impaired can also make someone crash or contribute to someone crashing as well, correct?
yes, that's correct.
So it's one of the possible reasons,
Yes,
not a many. Going to what you observed about Mr. Singleton prior to asking for consent for a blood draw. You testified that you saw his eyes were watery, and I believe on direct you said they were bloodshot too. Is that correct?
yes, they were.
Okay. And you said he talked a lot.
He did.
Did he repeat himself a lot?
He repeated himself. He spoke more than I expected him to. I would ask something and he would kind of have little words to go over instead of just answering the question.
And is that one of the things that you're looking for as far as clues that someone may be impaired, could
Yes.
possibly be?
Yes, it is.
And then, of course, he admitted to having beer earlier that night.
That
Correct?
is correct. So we had a beer with his pizza.
And then you testified on cross that you did do a test on Mr. Singleton, correct?
Yes,
Okay, that would have been on his eyes.
that's correct.
Ladies and gentlemen, let me interrupt the state for a moment to explain something. during your absence at one point, there was an issue that was arisen. There is a certain type of test that officers use in the field sometimes to test someone's vision, and that helps them to determine whether or not they need to go further for an evaluation of someone's intoxication level. In this particular case, it's my understanding that there was such a test, and that's the test that was referred to. That test, in order to be introduced as substantive evidence in a trial, requires someone who has medical training to be able to explain why that test reflects what it does. This officer, the trooper, we've had a pre-trial hearing in which I excluded that test because she does not have the training to introduce the results of that test. So in fairness to both sides, the state is allowed to ask her, was there a test that she relied upon to make a determination to go further? And I've allowed that question to be asked, even though the results of that test are not admissible in this court. So you may consider that only as to whether or not she was answering truthfully about the matters that went forward and why she went forward with her further testing or request for a blood draw. But you cannot hear the results of that test or even the type of test it was. But there was a test that was given, and according to that, I've allowed that question to be asked. So I apologize for the interruption, but and that was done over the defendant's objection. He objects to the idea that even the mention of that test should be made, but I've allowed it because of the line of questioning about what was she relying on before she went further.
Thank you, Judge. And as the judge stated, you haven't had that specialized training to be able to talk to the jury about that, correct?
That's correct. I
Okay.
haven't had any medical training on that.
But you were trained to do it in the academy.
That's
Part of your regular training.
Yes, that test was something that we had training for, not just in training, but also in E-Write. And it's a part of the rules of writing test.
Okay. And that was one of the things that went into your consideration of needing to go forward with a blood draw, correct?
That's
Okay. So to sum up, there was the bloodshot, watery eyes, the extreme talkativeness, and that as well. Okay. All right. I don't think I have any other questions, Judge.
We close.
Trooper, General McLeod also, or again, asked you about Mr. Singleton's eyes, correct?
Yes.
And per your testimony, this was around 4 o'clock in the morning, correct?
Yes.
He had been in a crash, correct?
Yes.
He had injuries, correct?
Yes.
Would it be reasonable to assume that Mr. Singleton was in pain?
Yes.
So it would be reasonable to assume that,
I'm going to object if he continues to ask for the make assumptions or speculation.
said reasonable. Judge, my questions were reasonable. Would it be this officer's reasonable opinion?
Overruled. I'm allowing the question only because it offers a possible other explanation for watery eyes.
Trooper, would it be reasonable in your opinion that the time frame and the level of pain could have caused Mr. Singleton to have watery eyes?
It is possible.
General also asked you again about Mr. Singleton being overly talkative, correct?
Yes.
And your testimony was that you received your training from the THP Academy, correct?
That is true. I'm in the secondary training for A-Write.
And so you're familiar with NHTSA as it relates to DUI detection, correct?
Yes.
Then you would agree with me that NHTSA does not list talkative as a validated clue, correct?
Yes, it is.
Now, I'm going to object again. I believe this was answered on cross. some detail. He's asking the same
Question
question.
has been asked and answered already.
Judge, and she brought it back up in her redirect about him being talkative. I'm just merely going off of her redirect.
Any objection? The question's been asked and answered. It's been established that being talkative is not part of those types of things.
Mr. Singleton was coherent, correct?
He was able to talk to me.
And he answered your questions, correct?
He did answer the questions.
Trooper, in your reasonable opinion, someone that had just been involved in a crash, would it be reasonable for them to be nervous?
I would say if it was closer to the crash time, I would think so, but not at the time I made it to the hospital. If they would still be nervous at that point.
Would it be reasonable to state that Mr. Singleton was injured?
Yes, he was.
In your reasonable opinion, do you feel like that can make somebody overly talkative?
No, for the most part, every time I come across someone who's been injured, they're the opposite thing. Like, they don't have much to say, they're tired, they're in pain, and they don't really want to talk.
In every encounter?
I can't say every single one, but well over the majority.
No further questions.
Anything else?
Yes, Judge. Trooper Whirling, in your reasonable opinion, could all of those things that we've been talking about, bloodshot, watery eyes, admitting to drinking a beer, the over talkativeness, the repeating himself, could all of that have been because his BAC was over 0.11?
That is,
No further questions, Judge.
Anything else, Mr. Mitchell?
No, Judge.
Thank you, ma'am. You can step down. Have a seat at the table with the DA.